And I believe if we can get questions from students and all the audience here, that will be wonderful if we could answer some of your queries. But let me tell you why mediation is so critical. I don't know how many of you read newspaper yesterday about a woman CEO of an artificial intelligence company who traveled after killing her own child from Goa to Chitradurg in Karnataka and arrested by police. And if you get, it was big news yesterday and very, very shocking. It was, whoever read it, it was like unbelievable and a chilling experience. But if you go in the root of that, you can just wish she was fighting a divorce case with her husband, and there was visitation rights to both, and that probably was a cause of concern and dispute. If there was one good mediator in her legal matter involved who won the confidence of the both parties and mediated well to resolve this issue, a precious life was saved. Mediation is so critical. I personally believe in all personal law matters, be it, marriage and or divorce, be it, all the personal law matters and even other petty offenses. It's high time our courts should compulsorily create a mechanism to involve qualified and trained mediators. And particularly those having legal knowledge can even be more effective in that way, that this kind of offenses could be avoided. So I would like to invite questions, but before that, so that's the best way to, make it interactive and also.
Yeah, so basically, one of the advantages of mediation is that if a criminal commits crime, he's not afraid to escape punishment, because there will be no punishment. Basically, he'll be escaping punishment, so he will not be getting any punishment. So he's not afraid to acknowledge and accept the crime. But the thing is that mediation, restorative justice, basically deals with pardoning a criminal. Now, if criminals know in advance that they are going to be pardoned, they are going to escape punishment, if they will go through mediation, then they will be more encouraged to commit crimes. And it is in contradiction to the deterrent theory, the punishment theory that we have. So there, it completely goes in contradiction to that and completely undoes the deterrent theory which we have for criminals. So this is one of the aspects of restorative justice that has to be seen, that whether restorative justice will be applicable everywhere in all sorts of crimes. Then we also have compoundable crimes. So we are already having compoundable crimes where crimes get sometimes pardoned by paying some compensation to the victim, by depositing some penalty or something like that in the state. So how restorative justice is going to find its place in society? Because criminals who commit crime, on the face of it, people say that they have forgiven the criminal, but the society actually doesn't forgive the criminal. They remain criminals in the eyes of the society. They tend to remember that in the past they had done certain mistakes, and they always have a lack of trust on those people for having committed those crimes. And on the other side, the criminals also try to take advantage of the system. And instead of getting prevented from committing crimes, they are set free to commit more crimes.
Sorry. Yeah, okay, yeah, which is good, and I understand your concern. However, if you're looking at just the agreement, the court always has to take it into account. You cannot get away with murder because of society says, well, that's unacceptable. So there will be some just form of punishment. That's definitely true. Secondly, that we as mediators, we're also not of the truth telling, whether somebody telling the truth or not, because we're not the investigators. That's up to the court or the police. But if it comes to apologies and forgiveness, we're looking for genuine. If it's genuine, if it's just truly just well meant, or is it just like, oh, I'm going to say it because then I can get away, or my sentence will be lowered. These are elements that we as mediators also just look at, just also because the public and society expects that from us, because we need to just protect society from these just wrong these wrong doing. So we expect them to just put a genuine amount of effort in the mediation just in itself, and it's going to be enforced. Whatever just is being just agreed. It's not okay. It's some sort of paperwork, and then I walk out of the door. There is that if it's again just happening, let's say we come to just an agreement, but if it's happening again, then you shall be just penalized. Period. Does that answer your question? Thank you.
And also the point I made was about preventing a crime. Of course, a crime is not just against an individual. Crime is always against the state, against the society. So once the crime is committed, nothing can be done. But I think the commission of crime itself could be avoided or potentially reduced if there is a good trained mediator, in cases like, these family disputes particularly. So essentially all these cases, court anyway refer a lot of family law related disputes to mediators, but I think we should make it almost mandatory to go it through the trained mediator, rather making mediator a part of the process. That will help this area also to grow and reduce maybe potential crimes like this. That was what I wanted to convey. Yeah, next questions, please.
सर मेरी क्वेश्चन, अगर थेफ्ट का कोई केस है, एग्जांपल लेते हैं, और हम थेफ्ट के केस में मीडिएशन में जाते हैं तो वो शॉर्ट आउट हो जाता है, तो क्या ये एक रेगुलर हैबिट नहीं होती है? हर कोई जिसकी प्रॉपर्टी स्टोल हुई वो चाहेगा कि मुझे रिकवरी हो जाए, अनलेस वो पुलिस के एफर्ट्स को, एफआईआर रजिस्ट्रेशन को और इतने सारे जो लॉन्ग बहुत सारे प्रोसीजर जो फॉलो किए गए हैं, उसके पुलिस द्वारा जो एफर्ट्स किए गए हैं सारी चीज़ें, तो अगर ऐसा ही होगा तो फिर ये थेफ्ट के केसेस में तो ये एक नेगेटिव अप्रोच का काम करता है कि हर कोई चाहता है कि मेरी प्रॉपर्टी मुझे मिल जाए, मुझे नहीं चाहिए किसी को अगर सजा दिलवाना या मुझे किसी को प्रोसिक्यूट करना, उसका मेन मोटिव नहीं होता है। अगर ऐसा ही होता है तो फिर ये एक रेगुलर हैबिट्स बन जाती है थीव्स की कि भैया एट लास्ट अगर मैं प्रॉपर्टी सरेंडर कर दूँगा। ये मेरा पर्सनल एक्सपीरियंस इसलिए भी है, मैं कोर्ट में बैठता हूँ, आई एम इन सेकेंड सेमेस्टर, और हैव सीन लॉट्स ऑफ केसेस जिनमें मैंने देखा है कि जो एग्रीड पार्टी है वो सिर्फ ये चाहती है कि मुझे मेरा पैसा मिल जाए। दे इवन डिनाइड फ्रॉम द एज बीइंग ए विटनेस, वो डिनाई भी कर देते हैं विटनेस के लिए, वो कहते हैं कि हम नहीं, हमें ध्यान नहीं है ये बंदा था या नहीं था, हमें अपनी प्रॉपर्टी मिल गई है। लेकिन अगर मीडिएशन में अगर ऐसा ही होता रहा तो क्या ये एक एनकरेजिंग नेगेटिव कॉन्सेप्ट अगर अप्रोच करता है? क्योंकि एक थेफ्ट का केस मेरे भी पड़ोस में हुआ था, तो एक पुलिस इंस्पेक्टर, ही वाज माय फ्रेंड, तो वो उसको डील कर रहा था, तो उसने कहा कि अगर आप लोग ऐसा ही करोगे तो फिर सजा किसको मिलेगी? अगर आप लोग अपनी प्रॉपर्टी को लेके, तो इनका एंकरेज होते रहेंगे, इनको मोटिवेशन मिलता रहेगा कि लास्ट में अगर हम प्रॉपर्टी रिकवर वापस दे भी देंगे उनको, तो इट मीन्स हम शॉर्ट आउट और हम सजा से फ्री हो जाएंगे। इट्स माई कंसर्न कि थेफ्ट के केसेस में, मे बी सीरियस केसेस में तो मीडिएशन का कोई रोल नहीं होता होगा, और इवन आफ्टर द मीडिएशन की अगर एग्रीड पार्टी अगर कोई इंजर्ड है तो वो फिर भी कोर्ट को अप्रोच करती है।
So that's indeed a good question. Have you gone through the new BNS Bharatiya Nyaya Sanhita? So I think the statutory answer to a question is in section 303, subsection 2. There's a provision of community service for petty theft in which person can go for community service instead of punishment or fine or both, provided that the amount of the thing he stole or the cash is less than 5,000. Or he can still go for community service if he returns the amount or whatever he stole, provided that this was his first offense. So, the more amount of property or whatever he stole, it directly correlates with the type of punishment that person will get. Again, we have statutes, we have everything, but at the end, that's the job of judge to decide if he should go for jail for 6 months, 1 year. For that, we have judges to decide. If you talk about mediation, there is, since theft is a more mainstream criminal matter, there is no scope of mediation per se. I mean, you can still go for plea bargaining, which is sort of mediation in criminal justice system, but again, it will be done under supervision of a judicial officer. They will supervise everything, and everything, I believe, will be just. Anyone else like to add?
So, the benefit of, I will say, mediation is there will be some relief to the aggrieved party, which otherwise may not be available through the court or purely through the, judicial system. Yeah, please.
Sir, we have to understand that restorative justice, the process is not so much per se for the victim, that is for the person who has committed this crime. So the session happens for that person who has committed his crime only after he has taken responsibility that yes, I have committed the theft, I have committed this amount of theft from this person, and we are here for the restorative process of that person. We are in this process to make that person know that you have committed a wrong. First of all, repair it, come to the status quo, and then please don't repeat it in the future. So much harm, so much has been caused to this person. You don't have to repeat this in the future. You have to better that person, not to claim compensation ourselves. We will get the compensation through police also, but the process that we want to take here is to make that person a better person for the society for coming forth. And when he admits to these crimes, yes, I have done it many times. Let's take a 0.1% chance he will not commit the crime again. It's a better process for the future. Even if one theft is committed less in the future, it's better for the society only, correct? So that's why restorative justice should be followed.
On the point of the offender or helping them, it definitely helps them, both parties. Because one case, a car hits a bike. He's almost the biker almost just gets his leg amputated. The guy who's just the driver, he wants to contact the victim. He's not allowed of police because of revenge, possible revenge. The only way they can contact is just first mediation. And he says, I want to know how it's going with the person on the bike. Because I don't know anything. The driver brings flowers to the mediation. And he says, finally, after all these years, I know what happened to you and how you're feeling. And I'm really just, I'm sorry just for that. For the offender, because he could not sleep in anything, now he finds closure. The other person, the victim, the biker, also finds closure because he was always wondering, why is he not contacting me? So they were both asking of each other and they didn't know it. So by having that conversation, a lot of things just can be just cleared out with a mutual understanding. So I would argue it definitely will also just empowers the victim. Yes, that's what it may do. And it can just help the offender just to find just closure, especially just in this case.
Such erudite explanations. one is encouraged to ask a question which one bothers a mind which reads. And that is the role of the technology down the line, throughout. The Palestinian, Israel, Lebanon, Iran fight has shown that the role of the air bombs and the drones and the missiles or rockets has changed the war methodology itself, where Israel or US, its main supporter, can come and say that I am going for targeted killing of a Hamas leader, but there is a, what do you call damage? Collateral damage. And they don't bat an eyelid, saying it that we have just killed 20,000 people who had committed no harm to anybody, including the birds around their houses. But we have killed them as collateral damage. We are not responsible to anybody. That's one point. And what retributive justice can we ever give to these families whose loved ones have died? And targeted killings of journalists, targeted killings of medical personnel, UN personnel, and so on. You read the list, and nobody has conducted in such a short time so many crimes coming from a small country, on a very, very small country. Having said this, the technology of EVs, driverless cars, tomorrow they hit, and in China where there are more, they have been hitting the passengers, pedestrians and so on. Who is responsible? Who is going to conduct the mediation? It was a driverless car. There is more and more robots in everyday life and industrial life, particularly. It's coming in personal life also. What there is something which goes wrong with the software of a robot in an industrial plant and kills 100 people. That happened in Tesla also. And no, I'm not actually blaming anybody. Now I'll come to what Mr. Aditya Mathur's biodata read about the cryptos and the, what do you call CFTs, NFTs, non-fungible tokens, right? To best of my knowledge in reading, this product in India is not legal. It's not legal. And I'm not arguing, I'm not a lawyer, I'm not going to argue anywhere else. But they are always defended when there is some issue. Now tomorrow there is a fraud, just like Sam Friedman's fraud was there. All the bitcoins that way are actually not a physical product. They're a virtual product with no inherent value at all, actually. There's no inherent value. There's no backup. We don't trust currencies like Indian rupees because there is no gold backup and all that. There's no backup. Now I know if we were to argue personally, Mr. Mathur will tell me a few things about it, why they are a product of value. But let's start it. They are a virtual money. Okay. And, I call it purely a mechanism for speculation. Having said this, give me the argument for a little while, and I'm talking about technology. They can be minted anywhere, including in Rohtak. There is one student of our engineering college student who has a blockchain factory in Rohtak, by the way, right? He does work for the Haryana board, Bhiwani, school board, okay? But he can also mint the coins, right? So in other words, the technology has also traveled. It's nothing so special which somebody is going to do somewhere and all that. But having pursued the case of Sam Bankfry and found it to be a total, what we say, क्या बोलते हैं उसको, what do we call a fraud? Fraud is a fraud though. I was trying to find a better word. Okay. It's a fraud, total fraud, you know. And it costs a few billion dollars to somebody. Who's responsible? Is Government of India going to be responsible? They didn't bring the legislation in time. If about few hundred crore rupees get lost, people do invest in India. They do. It's a global product, they'll say. Whose laws does it apply? Would the Indian laws not apply? Of course, the G20 have a committee of which our finance minister is the chairperson to figure out laws about it. So now what do we do about the retributive justice in this case? There is a Rakesh Khurana who says, I am a responsible citizen. I am warning the citizens they are getting into a fraud situation and here are the proofs of it. Right? Please don't. So मेरे को पकड़ लेंगे उल्टा. How have you seen? इतना बड़ा company उसके against आपने defamation किया. So I am kind of addressing it to you. How does one, as a class of problems, which is coming where technology is changing, right? That you can actually bomb a person right where he is in the bathroom, if you like to. But collateral damage is another 5,000 people. Then why do you call it that we are advanced, that we can do targeted bombing? That we will actually pay $10 million for a mechanism like this compared to a $1,000 drone, which will also kill 10, 15 people along with it. So, the orders of magnitude of what damage which can be caused, financially, runs into billions and in some cases trillions of dollars, where it is 10th amount of fraud. And in a country like India, we do tend to, even as professionals, as students and so on, tend to go in favor of USA and Europe, what they do, they must be fine, right? Okay, so this is just for you. This is, as I said, such good lectures invite interesting issues like this.
पता चला बातचीत में कि इंडिया में 4.5 करोड़ जो पेंडिंग केसेज हैं लिटिगेशन में, उसका वाई मीडिया हम लोगों ने मीडिएशन और एडीआर के थ्रू हम लोग उस प्रोसेस में हम जा रहे हैं. तो सर मैं ये जान सकता हूँ कि 4.5 करोड़ में कितने % जो हैं कॉग्निजेबल और कंपाउंडेबल ऑफेंसेज हैं और कितने % हमारे नॉन कंपाउंडेबल हैं. तो जहाँ तक मैं जान पा रहा हूँ सर कि जो कंपाउंडेबल ऑफेंसेज होंगे उसमें ही हम लोग मीडिएशन पे हम लोग जा सकते हैं. तो पहला क्वेश्चन तो मेरा यह है कि हमारा जो इसमें लिटिगेशन का इतना पेंडेंसी है तो वो सिर्फ जो नॉन कंपाउंडेबल ऑफेंसेज हैं उनकी वजह से है, नंबर 1, या हमारा जो जुडिशरी इंडिपेंडेंस थी उसकी जो कैपेसिटी है, कैपेसिटी ऑफ वर्किंग जो है, रादर वी कैन से कि इस्टेब्लिशमेंट में हमारी जो शॉर्टेज है, से सुप्रीम कोर्ट में 40% है, हाई कोर्ट में हमारे 50% का शॉर्टेज है, 20% शॉर्टेज हमारी डिस्ट्रिक्ट लेवल पे है. तो क्या इसकी वजह से ये हम लोग वाई मीडिया निकाल रहे हैं? हम सेक्शन 89 CPC का उसमें आकर के हम कहते हैं कि आप मीडिएशन पे आइए या और मीडियम पे आइए, जिससे कि हम लोग अपना इसकी पेंडेंसी को कम कर सकें. क्या ये डेलिबरेट जुडिशरी एक्शन है या इसकी ज़रूरत पड़ रही है? तो मेरे 2 क्वेश्चन है मेनली इसमें.
जी नहीं, बहुत अच्छे क्वेश्चंस आपने उठाए, बट ये जो मैसिव हम कहें डिले है और पेंडिंग केसेस हैं, इसका कोई एक रीज़न या एक फैक्टर नहीं है और इसका एक सॉल्यूशन भी नहीं है. इट्स अ वेरी कॉम्प्लेक्स इशू. सो वन ऑफ द फैक्टर्स is of course our judicial infrastructure. What you said, the number
this
of
is upcoming field.
जी
people are saying upcoming
so
field.
हाँ, so मैं आपका second point को पहले आंसर कर रहा हूँ. So India is not having a very robust judges population ratio. If you compare this with developed countries, we are 5 times a smaller number of judges. पूरा इतना बड़ा हिंदुस्तान के लिए the number of judicial officers are less than 18,000 if you look at the entire judiciary for the whole country. So there was a report of I think a decade back there was a report which had recommended to almost double the judiciary size. Means if we want a speedy adjudication of disputes, we need to raise our judiciary from say 16,000-17,000 judges to 30,000, 35,000 judges. And most of the disputes are in the district courts. The high courts and the Supreme Court number is much lesser. So, to strengthen district judiciary by providing maybe more robust infrastructure, even technology, and putting more judicial officers in job is one of the, I will say, uh, ways through which we will reduce this pendency. But that is also not the only way. We have to actually go for mediation in all these routine matters which, like, that is why a lot of lok adalat system is strengthened by government so much, the National Legal Services Authority, and at high court level and even at district level, the I mean, millions of cases are being adjudicated through that. So all the check bounce cases, for example, there are millions of cases under Section 138 of NI Act, which actually could be settled through mediation. There is no need to go to court for them, but they ultimately end up going to courts because we do not have a strong mediation system in place, where even at the time of filing the case, automatically it should go to a mediator first, and there should be certain, the award given by mediator, or if it, I mean, it should be considered at final. In many cases, it is final. So, we need to, I think, identify a list of matters which should be compulsorily going for mediation and not coming to courts. Because right now, everything goes to court. Even a small dot matters, for example, your tree in your campus hanging over your neighbor's land, and your neighbor is not responding to it, the only remedy you have is to go to court. Now it's very simple. Through mediation, through simple conversation, you can cut few branches of the tree and the litigation could be avoided. One docket could be reduced. But for this, there has to be a system in place, and we have, that these particular matters, or unless the, the compensation involved is of this amount, it should not be tried by a court. It has to be settled, through the mediation process.
सर कंपाउंडेबल जो केसेज है उसमें तो एलिजिबल है, ठीक है, लेकिन नॉन कंपाउंडेबल में मेरे ख्याल से
Of
इतना नहीं
course,
है.
grave cases, though,
नहीं हो
that they
पाएगा.
are offenses against the
अच्छा,
state.
number two, 50% of our population is female, male and female. 50% are females. The outrage of women modesty cannot be
Of
negotiable.
course, of course. So,
So we cannot say it is upcoming field, but it has certain fields.
of course, we can't apply mediation to every field,
Right.
But a
But
lot
most
of,
of the cases are, sir, non-compoundable. Sir.
so in criminal law, criminal matters are not, I will say, not completely the subject matter of it. Only petty offenses, petty wrongs, small crimes, which could be covered under this. Yes, of course, we have provision for this. But all these contracts, business decisions, commercial disputes, they all can go out of, the courtroom, and they are going out actually. Now companies, they are putting a clause in every contract that you have to adjudicate it outside courtroom. Both the parties agree that we won't go to court. That is what arbitration clause is. Every contract nowadays is with an arbitration clause. And that is how I think. No, I'm talking about civil matters, only the commercial corporate matters. Of course, G.
My point was that yes, compoundable offences can be handed over to mediation, and we can have mediation system in place. But again, one must remember that for mediation also we require judicial officers. If we don't have judges for normal litigation cases, even for mediation, we would require some specialized judges. In fact, the judges are more specialized for mediation than in normal litigation cases, because sometimes the subject matter is very different in mediation, and it requires specialized knowledge of different subjects. information technology and many other areas, knowledge is required, intellectual property knowledge is required. So those cases are much more different in nature, and judicial officers, specialized judicial officers are required for those.
We don't have judicial officers as mediators either in the court or in after court mediation, also like our arbitration proceedings. In arbitration, it's usually retired judges and so on. But that's the beauty of mediation. You don't have to be a judicial officer to be a mediator. Any person, even a lawyer, without a lawyer, anyone can be a mediator, given that he has some accreditation and he knows about this matter. Correct. He started with it. So that's the beauty of mediation. You
But
don't
then
have to
who
be
puts the stamp on the victory then?
correct. So after coming of this act,
The judge puts the name because it's all it's going just within the court. The judge is going just to do the final sign off, not we. So that's where just the responsibility just is going to be. Yeah, exactly. And what it does, like, okay, which case is just valid? We see a lot of prosecutors. They'll say like, okay, this case it could be possible for just mediation. When is one of the criteria to have it just possible for mediation? If they are willing to participate, and if they are just competent enough just to have just a conversation. Those are just the most two important just criteria to even just start with the mediation. If one party says, I don't want to have it, then you don't have a conversation. But already that intake, which we have in the Court of The Hague, is a mediation center. They will just discuss it just with the parties to see just what's which is possible, and then it will be referred just to mediation. So there is such that a safety net. Everything which we just agree, if there's no agreement, we only report back to the court. Case not solved. Not the reason why, because it's because of the form of mediation. It's confidential. We don't say anything just about conduct. Then it will be reported back. Only thing that we report back is just the agreement. The court has to take into account whatever it is, but it still rules something like, oh, it's great agreement, but you think you deserve some form of punishment. It's not up to us, it's still just up to the court. But it makes it easier in the whole end-to-end process that will shorten the time and the files. And I've seen the files when I visited the court in Pune, this was ridiculous. We can reduce that. We can all just do it together, and because there are plenty of cases for every just lawyers, for everyone just here in the room to make a decent living. But we need to just be more structured, more effective, as you already mentioned, Mr.
So, and in the Supreme Court, there is a committee which organizes mediators training programs, and in that process they authorize, once you complete that, they issue a certificate, and that certificate empowers you to become a trained mediator in a way recognized by the Supreme Court of India. So the Supreme Court committee, and high courts have also started those committees. So in that way, you are mediators recognized by the apex court, and that gives a certain weight to your decisions, and also helps in concluding the process. So that is what is needed to increase that cadre, because still a very small number of people are trained by that Supreme Court committee or High Court committees. Very small number of people. I think not more than few thousand. So we need those training programs, maybe that capacity to be increased.
We extend sincere gratitude to all the speakers and attendees for their active engagement and insightful contribution to this enlightening seminar. It was indeed a learning session where we got to know the meaning of restorative justice from Ojaswita ma'am, mediation being a conversation between parties from Pascal sir, growing scope of ADR from Anand sir, about the rare acceptance of mediation in general minds and the difference between mediation and meditation from Param sir, And although Aditya sir spoke at the last, he gave deep insights on training in mediation. We are really thankful to all of you.